Welcome to Obsessed with Success, starring Russel Morgan.
Welcome back to Obsessed with Success with Russel Morgan. Russel is the founder and CEO of Morgan Legal Group, one of New York's premier estate planning firms and a mentor to attorneys who want a firm that runs on structure and clarity. I'm Kevin Rosenquist, and today we're talking about equity. Russel will walk us through how ownership and partnership structures can either strengthen a law firm or pull it apart. Russel, welcome back.
Kevin, great to see you as always.
Yeah, great to see you too. I'm curious, when you first built Morgan Legal, what kind of ownership structure did you start with, and how has that evolved as the firm has grown?
I started as a solo practitioner in a one-room shop. And over time, first we added on some associates. Since then, we, of course, have added very selectively in our new offices certain other members that have now officially become members of our firm. So it's a process, like anything, it's taken some time. But as you grow and as you develop and as you move into new areas and new domains, you can't be everywhere at once, and you need to make sure you have the right suitors for the role before you make a decision like a partnership, which is something that I took very seriously before taking that leap.
Yeah, we talk a lot about on this podcast about how you can't do it all yourself, and that's a good example of it. So how, offering equity it's a big decision, it's a big deal, it's not a small jump. What are some of the important factors that you think people should consider before deciding to offer equity or partnership?
Partnership doesn't necessarily mean equity. There are a lot of variations of partnership, and you'll see this a lot on the larger, more corporate structured firms. Sometimes it's a title, sometimes there's some sort of profit sharing, and in some cases there is in fact equity. So for some, it's important that they are full-blown equity partners. For others, depending on your structure, it may be a form of profit sharing where you are a partner, but to a degree or to a certain area of practice or arm of the practice itself, not necessarily the overarching company, but an area or arm or delegation of the firm itself. So you have to be careful here, especially when we get into the world of equity and partnerships in general, because we are dealing with lawyers at the end of the day. So this is something that you need to be sure, you need to make sure is done right and should not be done yourself. As always, and I'll be the first to tell you, anytime you enter into any kind of partnership, regardless of what kind of business you're in, make sure at a minimum you're consulting, ideally that you're represented by equipped and experienced counsel that can help guide and structure your partnership long-term to avoid liability and avoidable breakdowns in the partnership.
I could see the wheels turning, figuring out a diplomatic way to say that. Do you feel like firms might rush into partnership decisions before they've built a clear framework of how ownership actually works day to day?
Unfortunately, I've seen it too often where, due diligence isn't really done, liability checks aren't done, conflict checks aren't done. You're just seeing somebody else with a book of business and it's, let's go forward. And you have to treat it the way you would treat any business. When you take on a partner, especially when you're in the area of practice, and practice in general, medicine, law, any type of practice, taking on someone's book of business inherently means you're taking on the responsibility, which means you're taking on the liability. So it all sounds great in dollars and cents, but you have to be careful that you're not stepping on landmines in the process and walking into somebody else's mess. So make sure that before you formalize your partnership, you really do your homework. Make sure you check their clientele book, make sure you check the status, where they are, that they're not delinquent on any deadlines, that they're not missing statute of limitations, that there's no latent or patent liability and exposure that you can now inherit just by becoming partners. And this is the mistake that I see so often, is people are so gung-ho on working together and making this into something bigger that they're not looking at the details. And really the details is where it comes down to. And those same details are going to affect your bottom line. They're going to affect your profit and loss statements, especially if you're dealing with liability. It can affect your insurance. It can affect your malpractice. So just be careful and make sure you do your homework before you enter into any kind of partnership, especially in the area of practice of law.
When equity is on the table, are there any specific things that tend to cause friction?
Anytime there's money on the table, usually there's some friction here.
True enough.
If you're dealing with someone seasoned and experienced, you're paying for experience, and it just depends on what you're looking for. Someone who's looking for a rainmaker who doesn't necessarily have a book of business but has the skills to operate as a lawyer and actually generate business may be willing to offer a certain sum. Someone who's looking for someone who's a bit more seasoned to strengthen their presence and strengthen their reputation and their overall ability to service their clients may be a bit more willing and forthcoming. And you may have a unicorn where you're getting the person who can rainmake, who can drive business, who has a book of business, and who can actually produce and add a level of experience and professionalism to your firm. And even in that world, you're dealing with someone that has years and years of practice, which is a good thing on the experience side, but can be a problem if there are patent and latent liabilities with the files that they're bringing on board. So be very careful and be specific on what you're looking for. Are we looking for a partner for the sake of being a partner for management purposes? Are you at a level where you need someone else who has a vested interest to make sure that your business is successful? Are you looking for a partner because there's someone else who's bringing a book of business? And that's a completely different type of structure. Mm-hmm. How are you formalizing this? Are they joining your firm? Are you opening a new entity? Is it a joint venture? So it really comes down to what are your goals and expectations, and the clearer they are at the beginning, and preferably in writing, the less headaches we'll have long term.
Yeah, it's interesting to me because like you said, partnerships in any business can be difficult or can be challenging, maybe we'll say, but balancing contribution with control when setting ownership percentages can be difficult too, because I don't know, a lot of people who start a firm could be a bit kind of control freaks. I mean, I'm guilty of it myself sometimes.
That's true. And look, we're going back to the question of equity. There are so many variations of partnership, some that have contribution, others that do not. Some are just partner on paper, so it really depends on what are you looking to add to your book? What are you looking for that will add value to your business, that will help you expand, help you grow, help you manage, and what's the expectation on the other side? Because you may be asking for a lot, but not offering enough. So it's a dance at the end of the day. And we're lawyers. We're all trained in the same school. We all have the same legal mind frame. So the clearer you are on setting expectations, realistic expectations, and understanding that someone with experience, someone with business is going to cost you some money, the clearer you are on both sides and well represented, the better off your partnership will be. You hear all these stories about these large firms and the wars that they get into when the partners start going at it. These are the things that we're trying to avoid. Whether it's something you're doing for yourself or something you're doing for a client, that's always what's in the back of our heads, is what happens when things go south. If things go south, how do we mitigate the expense? How do we make it as seamless as possible for an exit to take place? It could be because something happened maybe it didn't work out. It could be someone that no longer wants to be in practice or in that business anymore, and they just want to get out. So the clearer your agreements are, the clearer your terms are, the simpler it will be if there is ever a problem or a transition that needs to be made.
Do you think there are benefits to defining equity clearly early, even if a firm doesn't plan to bring in partners right away?
You have a duty when you bring on, depending on your type of business and type of structure, but you have to let your team, especially your associates, who are all in some shape or form for the most part, are looking for growth. Understand whether they are or even have the ability to be on the partnership track. And again, what that looks like is going to differ firm by firm, state by state, practice area by practice area. But it's the availability and the perspective that if things work well, that it is an available route. Because if there's no room for growth, the problem is you're stagnant. So you're going to start potentially losing people that otherwise are massive value adds to your firm if you can't offer something that either is available today or may be available in the future that gives them an incentive to continue doing better work and performing at a higher level. So make sure that you lay out as clearly as possible whether partnership is even something that you're looking for. Look, to your point, some of us are in fact control freaks, right? So we may not necessarily be looking for partners, or we don't want partners just because we're operating at a level where we don't need them, or you want to keep everything under wraps under your umbrella. And that's totally fine, just as long as you're clear to yourself, your team, and your associates.
When it comes to buy-ins, profit sharing agreements, do you feel like these affect the culture and performance of a firm positively if they're designed well? And then is it possible to design them so poorly that it makes negative culture and performance?
There's definitely room for both. When you're going through a transition period, especially something like a merger of two businesses, there's always going to be some friction. There may be some duplicitous staff, there may be overflow on work, there may be some questions on control, on standards of procedure, of compartmentalizing certain tasks. So yes, of course it has its positives. You're growing, you're taking on additional work, you have more recognition, you're able to service a larger pool of clientele. But if it's not done efficiently and effectively, it can be a major roadblock. And it's not something that is handled overnight. If you're truly merging, and let's say, you're taking two big businesses and you're making them into one, whether one is assuming the other or you're opening a new entity, there's always going to be some sort of overlap. You're going to have to map out your plan on not just what we're doing going forward, but how are we getting there? How are we getting to a place where we're now working in unison? And if you're in the legal realm or you're in the professional realm, aside from operating procedures and SOPs, you have ethical obligations. So there are certain things that you have to make sure are done legally and other things that have to be done ethically to make sure that your partnership is effectuated.
If you were advising a solo attorney who wants to grow, would like to add partners at some point in the next 5 years or so, would you tell them to start laying any groundwork now?
The earlier you're laying your groundwork, the better you are. And for yourself, if not for anybody else, understand what is your comfort level with a partner. Is this someone that you're looking for day-to-day operations, management? Are you willing to give up equity? Is it something that's even on the table? Because you're going to get what you're going to offer, right? So you're going to attract the kind of person that is a fit for your offer. And you may have unreasonable expectations and not really understand what the market looks like. So the sooner you get yourself on track with what a partnership could look like, first for yourself, with what you're willing to part with and what you really want someone else to have a vested interest in. And second, how do we effectuate it? What kind of people are we attracting? And how do we weed out, most importantly, and make sure that we do our due diligence before we even enter it to make sure that we're making the right decision without error?
Looking back, what do you feel like the clear ownership structure you have has allowed Morgan Legal Group to thrive that might have been harder if you hadn't had that clear ownership structure?
As simply as I can put it, when you have too many cooks in the kitchen, it gets a bit problematic.
Yeah.
And look, there are 1,000 different ways you can structure it. Publicly traded companies have boards of directors. We have management agreements. You have operating agreements. You have designations that you can make for certain roles to take place, even if you're operating at that level. But you have to be clear and concise, and it has to be in writing. The most common error that I can see is people are getting involved in some sort of joint venture without being clear on the terms and conditions. That your contracts are so important, both on the way in and on the way out. And the clearer you are, and this is why I stress, make sure you're well represented, make sure that everything is in writing, because you don't know what the other person is thinking. You don't know what's going on in their head. The only thing we can prove is what's in black and white. And if there's nothing that addresses the issue, it could be something that comes up in the future and it creates possibly some friction or some litigation or just a point of contention that has to be negotiated. And you're better off catching it sooner than later so that you can get back to business. Because the reality is, if you're in the business of expansion, at some point, you're going to need additional hands. Whether the partnership track is the right fit for you is a personal decision you have to make as an owner. And in our firm, then, and that's the most common principle, is we've been able to grow expansively because of leadership. And it doesn't necessarily mean partnership. Because to be frank, under my leadership, we have been able to excel. But I wouldn't be able to do that without the assistance and support and the continued passion from our entire team of associates. So regardless of whether you're taking on partners or you're growing as a solo, make sure that your structure is as clean as possible so that you can focus on what you're good at, your strengths, and your team can make sure that they cover the rest.
Yeah, it's partnerships are not for everybody, right? Like there's
Absolutely.
sometimes you can do really well, obviously. Sometimes it's just better to run the ship yourself. And to your point, you're not saying you did it all yourself. You have a dedicated, awesome staff that helps you. It just doesn't necessarily have to be a partnership.
That's right.
Yeah. All right. Well, that's it for today's episode of Obsessed with Success. To learn more about Russel Morgan and the Morgan Legal Group, Russell, how can we find out more?
You can catch us on social media at Morgan Legal NY on Instagram, Facebook, or X, 24 hours a day at 888-529-1315 or online at morganlegalny.com. Till next time on Obsessed with Success.
Thanks, Russell.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.